Also, former spokesperson of the President Muhammadu Buhari campaign organization and Ministerial Nominee Festus Keyamo has advocated for judicial reforms to ensure Nigerians get access to justice. Keyamo, who is also a senior advocate of Nigeria, told lawmakers while being drilled on the floor of the Senate that there is a need to unbundle the Supreme Court. According to him, it is imperative to create regional Supreme Courts to help the speedy dispensation of justice, especially cases involving lands and assault, which can be dealt with by lower courts.
As a qualified lawyer and a man who is even qualified for the office of the Attorney General of the Federation, but I venture the President send you to the Ministry of Justice with all your area of experiences. Do you think in the last 4 years, the powers of the Attorney General to grant nulli prosecute have met these 3 conditions? 1, that of public interest. 2, the interest of justice. And 3, the need to prevent abuse of legal process.
The Constitution, in the 5th schedule, section 11, defines the duties of the code of conduct of public officers. Yet, there is a committee going around usurping the functions of the Code of Conduct Bureau called the Oblak Committee, the Presidential Committee on Asset Recovery. Tell us and tell Nigerians, as a promoter and a defender of the law that you have said, why you have not defended all these people that have been illegally asked by a committee to come and give asset accounts or whatever to them.
We cannot give the Attorney Generals the power of the judiciary to perform the functions of the judiciary. But let me say that the conditions in Section 174 right now, the other scandalous provision there, you put conditions there, but you make them subjective. So Senator Dima is correct to the point that these conditions are put there. But the Supreme Court has ruled in several cases that you cannot question the discretion of the Attorney General. I think it is high time we amend the law to make the advice of the Attorney General and DPP subject to judicial review. It's high time. The Attorney General and the DPP cannot sit down in their office and exercise the judicial function and say you have no case to answer. The powers were put there to protect, of course, people who will be charged, with frivolous offenses. That's why they put the power there, so that the DPP can say, don't face trial because it will be frivolous. But on the other hand, it is subject to abuse where people who are actually guilty are freed by the DPP by advice. The diary of the Supreme Court I speak with you now is filled up to 2022. You cannot get a date at the Supreme Court now till 2022. Yes, now, except political cases. And the political cases are compounding the issues again. So, I don't know why it has not been possible to simply establish regional Supreme Courts. And so the Supreme Court in Abuja will only entertain constitutional matters, political matters, and election disputes. Matters that have to do with the interpretation of the Constitution, because at that point you need the Central Supreme Court to guide the entire Supreme Courts across the country. And I think this country is big enough now to have 6 regional Supreme Courts where appeals coming from those regions would end there in land matters, contract matters, marriage, and all of that. I mean, as the Supreme Court is designed today, you won't believe, distinguished senators, that a case of assault, I slap you, you slap me, will go up to the Supreme Court and be lining up with constitutional matters and political matters to be heard. That is scandalous. And that is why today, the cases at the Supreme Court are pending there for the last 10 to 15 years.